Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. This is the voice of Cheryl, and I am Toothless Tiger. And again, welcome to the Tiger's Den. Here we are, part 2 of YSL plea deals, or proof that plea bargains are, of course, the trial penalty. Tonight, we're going to listen to the young men that took plea deals. And I was going to start with Jeffery Williams, but we did get to hear from him the other day, so I'm going to save him to last in case, some people want to fall off. One of the things I loved that was going on during this trial is that we have so many people that were tuning in to so many different people. And there are people who, one attorney, and she's awesome. She just started last Tuesday, and she started with 66 people. And in less than 3 days, she was at 6,000 people. And she was able to monetize within a week. Some would say that's impossible, but it is not. It's what you bring to the table. And that's an awesome, awesome deal. She's an Atlanta attorney, and she had the opportunity to go on the lead attorney. And from that, the rest is history. One thing I love about being on YouTube, you get to bring yourself and you get to do what you want to do. And that's the beauty of having your own business. You determine how it's going to go. I was always told if you do what you love and willing to do for free, the money will come. The people will come. And everybody is not going to like your flavor, but you just give them you. And that's what I give authentically me every chance I get. I've been extremely busy and still in excruciating pain. But I had to do this because it's such a time as this that we, humanity, need to wake up and really realize where the power really lies. And the power lie within you. The people are the power. And until we start acting as if we have power, then we'll continue to be in the different situations that we find ourselves in daily. One of the things I think that we should do more than anything is start studying the Constitution for the United States and the Constitution for your state. Vitally important that we study those instruments. And we don't have to memorize them, but we should have some knowledge of what they're saying. And what are these rights that they speak of that we have that are protected by those documents? They don't give you your rights. They ensure that you know your rights, you have to enforce the Constitution by holding people accountable. And of course, we know that the election is over, so we're going to see things happening. I've seen things where one person won, and I'm seeing now the other person won. And, we're going to hear that back and forth for a minute. Whether you voted or you did not vote, I say vote for yourself and learn how to live in America. This is a global thing. It's international. And we need to learn jurisdiction more than anything. We need to learn status. And we need to learn venue. And that's something we're dealing with my sister's case. And we're fighting and working hard. And it feels just like the circus of the YSL case. However, in this situation, there are no pleas to be had. It's not a criminal case, it's a civil case. You just got to keep on fighting. As y'all know that I start out with a little education. I try to anyway. And I'm not going to be any different tonight. I'm going to start out with the beginning of the trial penalty that I started reading from. And I'm going to just show you guys where I'm coming from. I'm not going to read as much, but I am going to read the foreword, and then I'm going to read the recommendations. And then we're going to go on to the young men accepting their plea deals. I'm so happy for these young men, and I hope, against hope, that they get to have a new start. I'm not happy that they committed crimes. But for the grace, it could be any of us. And we know today you don't have to commit a crime to find yourself in prison for life. All you have to be is accused. And that seems to happen everywhere throughout the world. All you have to be is accused. The presumption of innocence belongs to you. Unfortunately, it doesn't work like that in the de facto court systems. A lot of people talk about voting, and they do vote, but look at Bonnie Willis. This debauchery that she has put before us, and yet she won again. Caring about nobody, seemingly. I don't know who she cares about, but seemingly I can only go by behavior. She cares about nobody. That she want to put away the notorious gang members. But the majority of the people that were doing the things that they call gang related, those people are out on plea deals. Men are fighting for their lives. And not only the chance at freedom, I mean literally their lives, because to know the life of prison, it's really, and I guess I should say prisoner, it's really horrific. And I've never spent the night in a prison, but I've certainly been inside prisons. And the horror stories that go with them, more are true than not. And then of course you always know the hero that's went to prison, let them tell it. And they came out, okay, they say. I don't really think so. But that's a world of its own. So, I want to talk about our sons and our daughters. And even us adults that are now being, plagued with being stopped and frisked and thrown to the ground and blown in the head and other places. This is the trial penalty, the Sixth Amendment right to a trial on the verge of extinction, and how to save it. Again, I said I was going to start with the foreword. This is the National Association of Criminal Defense Lawyers. And you know, Ashley Merchant, my shero, is a part of the defense lawyers in Georgia. Matter of fact, right now she's serving as president. And the Honorable Brian Steele has served in that position, and so has his wife. Several people have served. But they all are defense attorneys, and we really don't understand the job of a defense attorney and how hard it really is, because you have a system that you have an allegiance to, yet you have people that you see that are getting mistreated, and you want to give them all that you have to give. What I like to share with people is that it's a lot of darkness that rules the systems of this world. And you have to decide for yourself if you want to be the light. So it doesn't matter what system you're in and who's running the system. The choice is yours. It's just like if you decide to go off into politics, is what I call it. Politics is what they call it. You have to decide what you can compromise on, because trust me, if you go into those positions, compromise is sure to follow. And so you have to be the one that decide what you're willing to compromise with, on. If you can sleep at night, if you can look at yourself in the mirror or look at your children and still feel good about yourself being their parent. Those are decisions people have to make. And some of them are tough decisions. So a lot of us like to say we don't talk about people and we don't pass judgment. But a lot of us pass judgment, and we all talk about people, whether it's good, bad, or indifferent. That's what we do as human beings. We're more alike than we are different. And it would be real good if we could come together in our likeness and do better. They talk about the rap music and how they ought not to sing about this and sing about that, and they ought not. There was a time when they didn't. But the people that dictate the music industry dictate whether your song is going to be played or not, or whether you're going to be a star or not, based on how raunchy and how low you can go. Well, we know that a nation can only rise as high as it views its females. And in most of the places throughout the world, the female is not viewed at all. But we are very important. We are the givers of life. We are the first teachers, the first nurturers. And so if we're tainted, then everything that flows through us will be tainted, whether we intend for it to be or not. So we have to start banding together, sisters, and doing better. Showing a little bit of respect for each other. Respect just means that I see you. I acknowledge you. That's what it means. Hey, Asator. Good to see you. I want to thank everybody that's in the chat, in the bushes, in the trees, on the beach in Belize, the Bahamas, the cruise ship, the clouds, the sky, wherever you may be. Thank you for spending any time with me. I greatly appreciate it. I was running behind. I've been on the computer most of the day reading and writing some. And it's really a task that I wish for no one. But, you know, if you don't stand for something, you'll fall for anything. And I believe in standing. Even if I have to stand alone. I'm just that kind of girl. And I'll do it. Done it too many times. is the place to be. Sometimes. Sometimes it's a lonely place. And the warfare is in your mind. Not to mention the warfare that's plagued upon the people with the water, with the air, with the food, with the medicines. You know, we could go on and on and on, and we can't have real conversations because then people say it's misinformation, fake news. We can't be vulnerable to one another because then people say you're weak. You're nothing. But I believe in authenticity. And so if I have to be alone, then so be it. I'm a drama queen all by myself. I can do a 5-character play all by myself. And enjoy it. But we're going to talk about the trial penalty a little bit more, because people are seeing with the Young Thug trial, and it seems like a lot of people are falling off since Jeffery Williams has come home. And I hope that people will continue to watch the different people, because, you know, everybody give their own flavor. My favorite, of course, is Cat Not Williams, and then I love I'm Not a Lawyer But. And I just, you know, got turned on to the Fit attorney in Atlanta. But there's a young lady, Allie. She does very well. And she doesn't do long videos, but her editing is awesome, and she makes the point, and you get it. She had stopped making videos for a minute, I didn't see, but she's back making videos, and Liquid Concrete is back making videos, and you know I love her style. L.A. Pink is still doing her thing, advocating for the people. She was at the commissioners meeting, as she is always when they host a meeting and invite the public to speak. I believe it's for about a minute. And at the 15-second mark, they let them know. And then they cut them off if they haven't finished the sentence by the time that 15 seconds are up. They do that in city councils all throughout the United States. So that's, you know, nothing new. Kind of sad for the people that we put in office, but that's the way they do business. But this is about the organization known as NACDL, Trial Penalty Recommendation Task Force. And what they're doing is just trying to save the Sixth Amendment to the Constitution. So I said I was going to start with the foreword, but maybe I should tell you guys about the National Association of Criminal Defense Lawyers. The National Association of Criminal Defense Lawyers, NACDL, is the preeminent organization in the United States advancing the goal of the criminal defense bar to ensure justice and due process for persons charged with a crime or wrongdoing. NACDL envisions a society where all individuals receive fair, rational, and humane treatment within the criminal justice system. Founded in 1958, the year I was born, 66 years ago. Hey, Phil, it's good to see you. NACDL has a rich history of promoting education and reform through steadfast support of America's criminal defense bar, amicus curiae advocacy, and a myriad projects designed to safeguard due process rights and promote a rational and humane criminal justice system. NACDL's many thousands of direct members and 90 state, local, and international affiliate organizations totaling up to 40,000 members include private criminal defense lawyers, public defenders, active U.S. Military Defense Council, and law professors committed to preserving fairness in America's criminal justice system, representing thousands of criminal defense attorneys who know firsthand the inadequacies of the current system. NACDL is recognized domestically and internationally for its expertise on criminal justice policies and best practices. This is the part people don't want to know, but this is the part people need to know. And, I'm just one of them people that, I guess you could call me the go against the grain woman. Let's go on to the forward. A grand jury, for those of you who do not know how this system works, a grand jury presentation can consist entirely of information that would be inadmissible at trial. A prosecutor may knowingly use illegally obtained evidence to obtain an indictment. And if she has evidence in her possession that substantially exculpates the target, she may withhold it from the grand jury. Now, haven't we seen a lot of stuff that looks like this? And isn't it so apropos for them to say a she as opposed to a he? And what we've been looking at in Atlanta since 2022 and perhaps before. The presentation need only establish probable cause to believe the target committed the crime. If 11 of the 23 grand jurors are unconvinced that even that low threshold has been met, an indictment can still be obtained. And of course, it's all ex parte, so no one is even there to question the prosecutor's presentation. What accounts for all this? Why do our Supreme Court decisions and federal rules establish a charging process that guarantees that imperfect, ill-advised criminal charges can make it through if the prosecutor presses them? The answer is simple: because of trials. Those imperfect, ill-advised charges will come out in the wash when they are subjected to the cleansing effects of a criminal trial in open court. Indeed, when prosecutors know that such charges will go to trial, where they must be proved beyond a reasonable doubt to the satisfaction of a unanimous jury based on admissible evidence that is subject to vigorous challenge by defense counsel, to whom exculpatory evidence must be disclosed, they are not likely to bring them in the first place. This report is a major contribution to the discussion of one of the most important issues in criminal justice today, the vanishing trial. Once the centerpiece of our criminal justice ecosystem, the trial is now spotted so infrequently that if we don't do something to bring it back, we will need to rethink many other features of our system that contribute to fair and just results, only when trials occur in meaningful numbers. The first task in solving a problem is identifying its causes, and this report nails that step. Mandatory minimum sentencing provisions have played an important role in reducing our trial rate from more than 20% 30 years ago to 3% today. And that's on the federal level. And that's a part of that omnibus bill that was written by one of the senators known as Joseph Biden and was passed by one of the presidents that was truly loved by the Asiatic community, Bill Clinton. Instead of using those blunt instruments for their intended purposes, to impose harsher punishments on a select group of the most culpable defendants, the Department of Justice got in the habit long ago of using them broadly to strong-arm guilty pleas and to punish those who have the temerity to exercise their right to trial. That's what those sentences will do for you before trial. And if you have the nerve to go to trial, then they can really be gut-wrenching if you should lose at trial. The sentencing guidelines also play an important role, providing excessively harsh sentencing ranges that frame plea discussions when mandatory sentences do not. Finally, the report correctly finds that federal sentencing judges are complicit as well. And remember, whatever happens on the federal level is equally as bad on the state level. But this study was on federal crimes and federal prisons. In too many cases, excessive trial penalties are the result of judges having internalized a cultural norm that when defendants roll the dice by demanding a trial, they either win big or lose big. The same judges who will go along with the plea bargain that compromises a severe guideline range are too reticent to stray very far from the sentencing range after trial. The report's principles and recommendations will stimulate some much-needed discussion. Today's excessive trial penalties, it concludes, undermine the integrity of our criminal justice system. Putting the government to its proof is a constitutional right enshrined in the Sixth Amendment. No one should be required to gamble with years and often decades of their liberty to exercise it. The report properly raises the innocence problem. That is, the fact that prosecutors have become so empowered to enlarge the delta between the sentencing outcome if the defendant pleads guilty and the outcome if he goes to trial and loses, that even innocent defendants now plead guilty. But there's an even larger hypocrisy problem. Our Constitution claims to protect the guilty as well, affording them a presumption of innocence and protecting them from punishment unless the government can prove them guilty beyond a reasonable doubt. A system characterized by extravagant trial penalties produces guilty pleas in cases where the government cannot satisfy that burden, hollowing out those protections and producing effects no less pernicious than innocents pleading guilty. The report's recommendations range from the sweeping ban those mandatory minimums. To the technical, eliminate the motion requirement for the third acceptance point, and include suggested modifications to the relevant conduct principle at the heart of the guidelines. Pre-plea disclosure requirements, second looks at lengthy sentences, and judicial oversight of plea discussions. A particularly attractive recommendation would require judges sentencing a defendant who went to trial to pay greater attention to the sentences imposed on co-defendants who pled guilty. Few things place today's excessive trial penalty in sharper relief. And we saw that just by the things that we're going to hear here that these men were facing based on the crimes that they are accused of committing, pled guilty to, and was able to cut that time almost to nothing. How fair of a system is that? But yet they say this is the only system we have. No, it's the one we allow. There is no such thing as a perfect criminal justice system, but a healthy one is constantly introspective, never complacent, always searching for injustices within and determined to address them. The sentencing reform movement a generation ago disempowered judges and empowered prosecutors. Federal prosecutors have used that power to make the trial penalty too severe, and the dramatic diminution in the federal trial rate is the result. Our system is too opaque and too severe, and everyone in it, judges, prosecutors, and defense attorneys, is losing the edge that trials once gave them. Most important of all, a system without a critical mass of trials cannot deliver on our constitutional promises. Here's hoping that this report will help us correct this problem before it is too late. And they go on to acknowledge a lot of people. We're going to go down to where I left off, and I did the principles, and now we're going to do the recommendations. Recommendations, number 1. Relevant conduct, USSG 1B13, should be amended to prohibit the use of evidence from acquitted conduct as relevant conduct. Number 2. Acceptance of responsibility, USSG 3E1.1b, should be amended to authorize courts to award a third point for acceptance of responsibility if the interests of justice dictate, without a motion from the government and even after trial. And these are based on the points of the federal guideline system. Number 3, obstruction of justice, USSG 3C11, should be amended to clarify that this adjustment should not be assessed solely for the act of an accused testifying in her or his defense. Application Note 2 should also be clarified in this respect. Number 4, mandatory minimum sentencing. Mandatory minimum sentencing statutes should be repealed or are subject to a judicial safety valve in cases where the court determines that individual circumstances justify a sentence below the mandatory minimum. Number 5, full discovery. Defendants should have full access to all relevant evidence, including any exculpatory information, prior to entry of any guilty plea. Number 6, remove the litigation penalty. The government should not be permitted to condition plea offers on waiver of statutory or constitutional rights necessary for an accused person to make an intelligent and knowing decision to plead guilty. This includes an accused person's decision to seek pretrial release or discovery, investigate a case, or litigate statutory or constitutional pretrial motions. Number 7. Limited judicial oversight of plea bargaining. There should be mandatory plea bargaining conferences in every criminal case supervised by a judicial officer who is not presiding over the case, unless the defendant, fully informed, waives the opportunity. These conferences would require the participation of the parties, but could not require either party to make or accept an offer. In some cases, one or more parties might elect not to participate beyond attendance. That's true, Phyllis. The courtroom ain't no joke. Number 8, judicial second looks. After substantial service of a sentence, courts should review lengthy sentences to ensure that sentences are proportionate over time. Number 9, proportionality between pretrial and post-trial sentencing. Procedures should be adopted to ensure that the accused are not punished with substantially longer sentences for exercising their right to trial or its related rights. Concretely, post-trial sentences should not increase by more than the following: a denial of acceptance of responsibility if appropriate, obstruction of justice if proved, and the development of facts unknown before trial. Number 10, amendment to 18 U.S.C. 3553A6. In assessing whether a post-trial sentencing disparity is unwarranted, the sentencing court shall consider the sentence imposed for similarly situated defendants, including, if available, a defendant who pled guilty in the same matter, and the defendant who was convicted after trial. The sentencing court shall consider whether any differential between similar suited defendants would undermine the Sixth Amendment right to trial. Those are the recommendations that they're making on the federal level. And again, I say anything that's on the federal level, do know it's on the state level, because the state is the actual place where the people live. And that's either in the state of mind or the state of occupancy as far as the land. And with that being said, we're going to bring this to a close. And get into our videos. That's Mr. Williams. That's his attorneys. Opening statement. Okay, we're going to start with Mr. Nichols. He was the first one to take a plea.
The Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5.
So what we're going to do is we're going to hear these charges that he was charged with, that they want to give him all those years for because he's such a horrible person. But we're going to come to the conclusion that if he just say he guilty, we're going to see how they're going to take away a lot of things. And you must ask yourself, Could this be real? And I would say to you, it's really real. And I'm happy for these young men. Make no mistake about it. No mistake. Because these guys were facing some horrible sentences. And most of you probably have seen this. Some of you have not. And that's some of you that will be looking at the playback, of course, because we know we don't have many in the chat. But be that as it may, we want to just get the word out. And let me get my screen sharing back up. Because one day some mama's going to need to know. Just, where do I get started? I hope the time would come when we wouldn't have so much of that. But unfortunately, it's not getting any better. So here we go. Let's see what they say.
All right. State, spell your first last name for the court. So I will clear my please, sir.
Quay Nichols, Quamarvious, last name Nichols, Nichols.
Did you get that? Is that? Okay. Do you want to do it again? All right. Slow down. Your name. Spell it for this young lady right here.
Okay, my name is Quamarvious Nichols, first name Quamarvious, my last name Nichols, Nichols.
And Mr. Nichols, are you the same person referred to as Quamarvious Nichols on indictment 22 SC 183572?
Yes,
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
no,
Have you had the opportunity to sign this indictment with your attorney, Mr. Bruce Harvey?
yes,
How old are you?
29.
And how far did you go in school?
I got my GED.
I did not hear you.
I got my GED.
Are you able to read, write, and understand the English language?
Yes,
Do you understand that in this indictment, you were initially charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carried a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that is what you were initially charged with?
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had an opportunity to go over and review the waiver of rights form with your attorney?
yes,
And I'm going to hand this to your attorney. Did you sign this along with your attorney?
yes.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes,
Do you need any more time to discuss this man with your attorney?
no,
Are you satisfied with his counsel and representation?
yes,
And I'd include in there the counsel and representation by Ms. Westmoreland and Mr. Garland as well. You had a team of attorneys.
That's correct.
All
Judge.
right.
And they are all attorneys of record and have participated in this particular proceeding and negotiations leading up to this proceeding.
Thank you.
Do you waive formal reading of the indictment?
Yes.
yes,
Do you waive any and all defects with respect to the indictment?
yes,
And to your knowledge, have you been arrested on all the charges in this indictment?
yes,
And Mr. Harvey, the state is unaware of any outstanding warrants related to these charges. Do you know of any outstanding warrants that are related to these charges?
Not related to those charges.
Have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balanced on probation?
Yes.
Do you understand as a part of the negotiated agreement, the state will null, prosper, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon. Do you understand that is the negotiated agreement?
Yes.
Do you understand that the court?
Can you imagine Fonnie Willis going on national TV telling everybody that she's going to get rid of people with these type of charges and then turn around and dismiss all of those charges because they pled guilty to a racketeering charge, which he did not do? We'll hear that in a moment. But because they pled guilty to one charge, they dropped all of the charges. Boy, this is amazing. And had this not been Mr. Harvey, I don't believe that this would have happened. These lawyers are excellent in what they do, and they have worked tirelessly on this case. And I commend them for their honor and integrity, and whatever they had to do to make things happen for their clients, they did it.
Court does not have to accept that recommendation.
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other.
Yes.
Well, there's only one charge that
So
a guilty plea is
I
being
listened
entered into, so
under my breath to that.
there's no other sentence to run anything consecutively with
Right.
regard to this plea. You understand that?
Yes.
Okay.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
Do you understand you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Partisan Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse?
And for those who don't know, the Department of Paroles is a state level, in the Board of Pardons and Paroles, of which she spoke was of the federal level.
Or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? After each right, I'll ask you to say yes or no if you understand. The right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assist of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And that can challenge anything about the constitutionality of the plea. It's not limited to voluntariness, understand?
Yes.
And Your Honor, if this case were to
Hang on
continue-
just a second. You also have, so 4 years for that, to file a direct appeal. You have 30 days from the date of sentencing, which is going to be today. And you have until the end of this term of court to file a motion seeking to withdraw your guilty plea. That doesn't mean anything like that would be granted. You would have to establish facts that would warrant that. But that's just the time period is until the end of this term of court. Do you understand those as well?
Yes.
All right.
Your Honor, if this case were to continue with trial, Your Honor, the state would expect, as to this defendant, the state would expect to show that what has already come into evidence, that on July 3rd, 2017, as well as October 23rd, 2018, that this defendant is an associate of the enterprise of YSL, also known as Young Slime Life, and that he conspired to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, this defendant engaged in the activities below. He engaged in activities that assisted with preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity to include murder, assault, and threats of violence. That this defendant preserved, protect, and enhance the reputation, power, and territory of the enterprise by the posting of messages, images, appearance in videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, and to obtain money, weapons, and other property through acts of racketeering activity, including the unlawful sale and distribution of drugs. Your Honor, evidence has come in during this trial that on July 3rd, 2017, Mr. Nichols was located at 2612 Steele Avenue, which is in the Cleveland Avenue sector of the city. Your Honor, he was found inside of a vehicle. When that vehicle was searched, Your Honor, this was in October 2018, they found marijuana as well as sandwich baggies that would be used to package drugs. And there are also guns found inside of that vehicle. Also in July of 2017, this defendant was stopped during a traffic stop in the Cascade area, Your Honor. After being stopped, Your Honor, there was a consensual search of the vehicle that yielded powder MDMA, Xanax, as well as a loaded gun inside of that vehicle. Additionally, Your Honor, in July of 2019, Mr. Nichols was featured in a video with another YSL member, Shannon Stillwell, and Woody Lee. In that video, it was entitled Slap Talk. And in that video, co-conspirator Shannon Stillwell, while performing, makes such quotes as, "Me and my slimes are above the law." We know from the evidence that slimes is one of the terminology used by members of YSL to refer to themselves or other members of this enterprise. And then last but certainly not least, Your Honor, that in March of 2022, Your Honor, Mr. Nichols was found in surveillance video at a gas station at Windsor Street and Fulton Street here in Atlanta, Georgia. This was on March 14, 2022, during what the state would believe to show an onset of a gang war that really started in 2015 with the death of Donovan Thomas, that carried on into 2022. In February of 2022, a rival gang member by the name of Rayshawn Bennett, also known as YFN Lucci, was stabbed at the Fulton County Jail in February of 2022. Information about that stabbing was made public at early part of March 2022, around March 3rd of 2022. Once that information was released to the public, there was an onset of retaliatory activity that occurred between March 3rd, 2022 and March 16th of 2022. That includes a March 11th homicide of YSL associates Christian McMiller and Darius Ford. It also did include a retaliatory shooting of a YFN associate, and then ultimately it led to a murder of Shamel Drinks, who we believe is a YFN associate. This murder occurred again on March 14, 2022. Mr. Nichols is seen on surveillance video at that BP gas station, as I just referenced earlier. He was at the gas station with YSL co-conspirator Shannon Stillwell. Mr. Stillwell was driving an Audi vehicle. Mr. Nichols came to that gas station in a Ford Fusion vehicle. You see both of them on camera together. While they are at that gas station, Shamel Drinks approaches that gas station as well. I think unbeknownst to Mr. Drinks, Mr. Stillwell was still in his vehicle, which is the Audi. At some point in time, Mr. Nichols got to his vehicle, the Ford Fusion. Once Mr. Drinks finished his business or finished handling business at that gas station, we know that there is a phone call between occupants of the car that Mr. Stillwell was in and occupants of the car that Mr. Nichols was in. That communication was to the effect of, you need to get on FaceTime. As soon as that conversation ensues, we see Mr. Drinks leave the gas station in his vehicle, and both the car that Mr. Stillwell is driving, as well as the car that Mr. Nichols is driving, both follow out of the gas station, following behind Mr. Drinks. Mr. Drinks proceeds down the street to the light at Windsor, which is right by I-20 in Windsor. Mr. Drinks is in the far left lane. The car involving with Mr. Stillwell pulls up to the middle lane, and Mr. Nichols' vehicle pulls up to the far right lane. This is all captured on surveillance video and surveillance camera. They are at the light for a moment. Then we see both this car with Mr. Stillwell as well as the car with Mr. Nichols drive through a red light, leaving the car with Mr. Drinks sitting at that light. About 30 minutes later, a Good Samaritan sees that car still sitting there, approaches the vehicle, and Mr. Drinks is now deceased inside of that vehicle. We had know through LPR readers that both Mr. Stillwell's vehicle and the car involving Mr. Nichols drive in the direction of 20 westbound and follow in tandem. 2 days later, when after the case is investigated and arrest warrants are taken out, on March 17th, 3 days later, Mr. Nichols is found with Mr. Stillwell at a Chick-fil-A gas station, Chick-fil-A restaurant. There is a chase, I won't call it a high-speed chase, but there is a chase through the city of East Point, and eventually Mr. Nichols as well as Mr. Stillwell are both after arrest warrants were ultimately taken out for the murder of Mr. Drinks, Your Honor. Given where we are in the case, Your Honor, we know that Mr. Nichols, we do not believe Mr. Nichols was in the vehicle in which the shooting occurred, but he was in this other vehicle. The state has made a decision to move forward with this recommendation for the RICO count, Your Honor, for count 1.
Mr. Harvey, are y'all acknowledging a factual basis to the count 1, the RICO count?
Okay, we are acknowledging a factual basis. There has already been evidence with regard to the July 3rd, 2017 drug event, the October 23rd, 2018 drug event. We categorically deny and contest any use of violence by Mr. Nichols. We don't agree to that underlying factual basis. We believe those two predicate acts that were committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy. A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
Well, that's what the language of the statute says, but he
Yes.
is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations other than those two events that are sufficient for a factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are, substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act. So that.
Look at that look on Love's face. She's very upset about it. And she can't believe this. But listen to what happened. She already know that it's been negotiated. This is of no surprise to her.
But yes, we acknowledge a factual basis to that extent, Your Honor.
Understood. All right, thank you.
Your Honor, we just have one additional thing to say.
Go ahead.
The factual basis regarding the nature of YSL is that the evidence has shown and will continue to show that Mr. Nichols conspired with others to participate in Young Slime Life through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature of and asserted dominance of Young Slime Life, also known as YSL. And that concludes our factual basis.
And again, once again, we categorically deny those representations. And again, the only thing that is necessary to meet the factual evidence of a 1614-4C is proof that the defendant conspire with another person to violate one of the substantive provisions of RICO, and that is subsumed by the drug offenses that have already been proven in this case and to which Mr. Nichols has previously pled.
All right, thank you. Understood.
And Your Honor, may I approach with the waiver of rights form again?
Yes. All right, Mr. Harvey, have you reviewed with Mr. Nichols, this plea of guilty and waiver of rights form, which the two of you have both signed?
I have, Judge, in each individual provision in that plea colloquy has been acknowledged and gone over personally with Mr. Nichols.
All right. And Mr. Nichols, have you had sufficient time to consider this guilty plea that has been negotiated between the state and your attorneys, and to discuss anything you wanted to about that with your attorneys?
Yes.
All right. And you understand, I hope, I'm going to ask you, that it is your decision ultimately, obviously with the advice of your attorneys, but it's ultimately up to you individually to decide whether you want to enter this guilty plea or not. Do you understand that?
Yes.
All right. And you do want to enter this guilty plea?
Yes.
All right. And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does not ultimately go through with this guilty plea, and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
very thoroughly, Judge.
All right. All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than the statement with regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days, and he will be 30. And at 30 years of age, he has a wife. He has got a 13-year-old daughter. He's got a 10-year-old daughter and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta. And, you know, we're at this point before I have even given my opening statement in this case.
Yes, sir.
I do want the court to know that Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area. So he has come to this point in his life from a very humble beginning. And he has sought the support of friends in this courtroom and others in this courtroom. He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence. And I think this is in his best interest. I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I ask the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. All right, I find there to be a factual basis for the guilty plea to the RICO count one of the indictment, that being a conspiracy to acquire control or interest in money and personal property through a pattern of racketeering activity. And that is the only count that guilty plea is being entered for. The remaining counts of this indictment as against Mr. Nichols are being null pros by the state as a part of this indictment. I find, having heard the evidence up to the point of trial right now that there is evidence of at least one overt act in furtherance of the conspiracy, and that there is evidence that would fall within the required statute of limitations to establish this RICO conspiracy count. One of the things that we as judges are instructed by our Uniform Superior Court rules to do when we are considering whether to accept a guilty plea and whether to accept a negotiated sentence, and this is a negotiated sentence in this case, is to take into account whether giving leniency in sentencing is going to aid in ensuring promptness and certainty, or at least more promptness and more certainty with regard to corrective measures, whether the defendant, and in this case, the defendant has acknowledged guilt and is accepting responsibility for his guilt of the RICO count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count one of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count one is the sentence that has been negotiated of 20 years to serve 7, with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special conditions in those, so there are none as far as I'm concerned.
All right. Okay. So with regard to the time that you are on probation, you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you, and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe, Mr. Harvey is correct, can be a productive member of society. And this is an opportunity for you to do that, and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you, and set a good example for them, an example that I guess unfortunately you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you, Judge.
And Ms. Taylor will make this an exhibit to the plea. Thank you.
So he left the courtroom and went into custody to start his new life. And I say, thank goodness for new beginnings. Whereas it's unfortunate that he had to go and spend more time in prison. He's been locked up for 2 years, a little over. But at least it counts toward the time that he's, has left to serve. A lot of people are of the opinion that it should go this way, it should go that way. But until you walked in this position, and I haven't walked in this position, but I've walked with many of people in that position, you just don't know the devastation of incarceration. We can see it in our community because so many men are missing out of their families' lives as well as their children's lives. Some men don't even get to hold their babies. They don't get to meet them in the free world until they're adults. And this is devastating. And a lot of women now are going to prison, and they're taking them at childbearing years, and they're taking them away from their children. So a lot of them in the women's prisons, that's one of the loneliest places I heard on Saturdays and Sundays, whereas the men prisons are generally overflowing with visitation. But a lot of the women prisons, they're not so much. Now, they do get visits, some of them, but a lot of them, their moms or their great aunts are rearing their children. And, they're past the years where they can jump up and run up and down the road, because most prison systems, especially state prison systems, are all scattered out in rural communities, giving, that area economic base where people have jobs. And so a lot of the people that work at the prisons are related. And a lot of the people that go up in rank, they start as a CO, which is a correctional officer, and they may end up being the warden over a prison, or the major, sergeant, lieutenant, captain, that's their ranking. So it's really devastating. Most women will wait for men to come home from prison, where most men won't wait for women. And they end up developing families of their own in that world, men and women. It's a whole different animal. And I guess that's why they have them in cages, because it's really an animalistic mentality that we call institutionalized. But again, this is the only system that we have. And until the people decide that things need to be different and better, and participate in the decision making, not that you're going to be the one at the negotiation table with the people that make the decisions, but you can certainly be at the table with the ones that you send to negotiate. That's something that you can participate in, whether you vote or not. As a human, we all have unalienable rights, and so we should participate. Now we're going to go to Little Rod, and these pleas are very touching to me, because these young men, he's been locked up for a while. He's a young man. He's just 20 years old, going on 21, and he reminds me of my great nephew that I call my grandson, so much so. And I'm just so proud of him, how he has changed since I started looking at the trial. He got rid of all the big dreads and the weird hairstyles. He started reading, and I'm told that he's studying to be an attorney. I don't know if that's true or false, but I wish him the best in his endeavors. He's been in prison on a life sentence, and he has an opportunity, if at all possible, that he may get to come home one day. His case is up for appeal. And from hearing Mr. Steele argue for his, partner in crime, they call them. It sounds like some shabby stuff was done. These DAs are horrible, and it's really sad because these are professions and careers that these people spent years going to school for and learning their craft. And I don't know if they ever perfected practicing their craft. I don't know. But it's really, really, really disheartening to see. But I was so happy. And Mrs. Abadi, she was just, I think that's her name. It might be something else because that Abadi sound like that man's name that's over there on the prosecutor side. But we'll hear it. She was absolutely great. So let's listen to Little Rod. Child, I thought y'all was looking at the video. Thank you, ass. I'm sitting here looking at the video and dropping links, and I thought y'all were too. Hold on.
Yes, sir. Rodelius Ryan, Rodalius Ryan, Ryan.
And Mr. Ryan, are you the same person referred to as Rodalius Ryan on indictment number 22SC 183572?
Yes, ma'am.
Are you at this time under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you?
I'm currently 20 years old,
And how far did you go in school?
12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged in this indictment with count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organization Act, which carries a sentence of 5 to 20 years?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had an opportunity to go over this plea of guilty and waiver rights form with your attorney?
Yes, ma'am.
And have you and your attorney both reviewed it and you signed this document?
Yes, ma'am. That's my signature.
That's your signature?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Leah Abbasi, about all of the facts and circumstances known to you regarding charges in this indictment?
Yes, ma'am.
Have you been able to speak with her about any potential defenses?
Yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her counsel and representation?
Yes, ma'am.
You also had another attorney, Ms. Angela D. Williams. Are you satisfied with her counsel and representation?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes, ma'am.
And do you waive any defects, if any, with respect to the indictment?
No, ma'am. Can you repeat that for me?
Sure. Do you waive any and all defects in the indictment?
Yes.
And have you been arrested on these charges, specifically count 1, the conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act?
He was already in custody, so he was not taken into custody for these charges. However, he was booked for the charges in the Fulton County Jail.
And he was served with the arrest warrants on this.
Yes.
Has Ms. Abbasi advised you of the minimum and maximum sentence for the charge that you are pleading to?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve, commuted to the time you have served in this case? Do you understand that?
Yes, ma'am. And
do you understand that this sentence should run concurrently with the sentence that you are already serving for 19 SC 168236? Do you understand that?
Yes, ma'am.
Do you understand that the court does not have to accept this recommendation?
Yes, ma'am.
And the court can sentence you to the maximum on this charge?
I understand.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you are not in
I'm
the
sorry,
United
one
States?
moment. Please repeat the question. Do you
The one on
understand that the
enhancing
convictions?
sentence, that one, the one on enhancing sentence?
Yes, I just needed to explain a bit more what that means.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, and transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? And after I say each right, I'll ask you to respond, okay? The right to trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assist of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of these charges after trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes, ma'am.
Do you also understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
And do you also understand that you have until the end of this term of court to file a motion seeking to withdraw your guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed and continue with trial, Your Honor, evidence has shown and will further show that Mr. Ryan conspired with others to participate in the Young Slime Life gang through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature and dominance of Young Slime Life, aka YSL. Your Honor, the court has been present for evidence regarding the February 23rd, 2019 homicide of Mr. Jamari Holmes, in which Mr. Ryan and YSL co-conspirator, Damon Blaylock, lured both Jamari Holmes, Bernard Mitchell, and Rodney Uten to an apartment at 50 Mount Zion Road, which is in the Cleveland Avenue area. The evidence came out that during the course of that incident, that Mr. Ryan, along with Mr. Blaylock, emerged from the apartment complex, shooting at the vehicle which Mr. Holmes, Mr. Uten, and Mr. Mitchell were in, shooting Mr. Holmes in the head. After this incident, a few hours later, Mr. Ryan is seen posting on social media, on a public social media post, saying that YSL makes the news. Right, there has been other social media posts in which Mr. Ryan has promoted or enhanced the reputation of YSL. Your Honor, the state intended to show further evidence that once Mr. Ryan was convicted of the homicide of Mr. Holmes while in prison, he continued to enhance the reputation, power, and territory of YSL. Specifically, when YSL co-conspirator and co-defendant Christian Eppinger was given a bond for shooting at an Atlanta police officer, Mr. Ryan, while on a contraband phone in prison, posted on his social media account, he flashed the YSL sign and stated, "We're coming to get you. YSL shit, free my N-word bris, F the DA, the gangway, we catch a bond on this shit." Your Honor, this is the evidence that the state would have intended to show if we would have continued the trial. Given the current status, Your Honor, we've made an offer to Mr. Ryan for this community time served offers my concurrent with his current conviction, Your Honor. And I can approach with the documentation.
You may. And I wanted to just add one thing to the information about the different methods you have to file things after this plea. And that is that Ms. Williams and Ms. Abbasi will represent you until either the end of this term of court or 30 days, whichever's later. And so they would be the ones to talk to about filing those things, unless either of them is permitted to withdraw before that time. They would be the ones to file those for you, okay?
Yeah.
All right, Ms. Abbasi, is there anything that the defense wants to add to the record?
Yes, Your Honor. Your Honor, I have had the honor really of representing Mr. Ryan along with Misty Williams, who I'm quite disappointed she could not be here today for an important day. This trial has been exhausting for everybody, and that certainly includes Mr. Ryan, who has been going through the court system since he was 15 years old. We categorically and adamantly deny that YSL is the criminal, dangerous street gang, which it's been made out to be through this trial. We're actually quite happy with the record, which was established during the presentation of the state's evidence of the alleged murder of Mr. Jamari Holmes. This plea today, Mr. Ryan is making a decision which is going to be the best for his future, what future he has, because he's already serving a life sentence. Were he to be convicted and sentenced to additional time, he would remain in custody. As I stated, we think the record established will strongly support his appeal, and hopefully, when his conviction is overturned, we don't want him sitting in prison for something else. Certainly not for actions he took when he was younger, and actions he took which are largely a product of how he grew up. As I stated, Your Honor, Mr. Ryan was 15 years old at the time of the Jamari Holmes murder. You've seen through the text messages, he was out at all different hours, doing all different things, which I don't think anyone would want their 15-year-old to be out doing. And so that is where he was, and so he did adopt the people who were around him, the people who could support him, the people in his neighborhood who grouped themselves, calling themselves YSL. Mr. Ryan at no point was trying to advance a criminal street gang and their interests. He was trying to protect himself, being a young person, largely on his own, and this is where he's ended up. I would like to say that there's been some sort of rehabilitative function here since he was sentenced to prison. It doesn't appear that that has happened. As you've heard, some of his additional cases are within the prison system. It would be wonderful if some of the money spent on a case like this could possibly be invested in the future of people like Mr. Ryan, who go into custody at such a young age, and who really then are not given the resources to make the changes that they really would like to make to have a productive future. With all of that said, I think Mr. Ryan has grown up a lot during this trial. He doesn't want to sit through this anymore. He doesn't want to ever be back in a courtroom ever again, Your Honor. He's heard about all sorts of incidents, which the 2015 crimes, he was 11 years old. Mr. Ryan's most sincere wish is to move on with his life, to put this behind him. And we thank the court for the opportunity to resolve the case in this way and not drag it out any further than it has been.
All right.
He just would like to thank the court, Judge.
All right, thank you. And Mr. Ryan, I just want to make sure that you understand that this is ultimately, the decision is yours to make, not your attorneys. And I appreciate that both Ms. Abbasi and Misty Williams have been available in giving you legal advice and guidance, but it's ultimately your decision. Do you understand that?
Yes, ma'am.
All right, and do you in fact want to plead guilty?
Yes, ma'am.
All right, and you've had enough time to think about it and to discuss it with your attorneys?
Yes, ma'am.
All right. And Ms. Bossi, have you and or Mr. Williams talked to Mr. Ryan about the benefits and drawbacks of all of his different options?
Yes, Your Honor.
All right. All right. I find that there is a factual basis for the guilty plea to count one, the conspiracy to violate the RICO Act. Whatever the difference of opinion may be with regard to what YSL is or isn't, and what Mr. Ryan may or may not have intended, there is a factual basis that exists from the record as it already is in this case to support the necessary elements of the conspiracy to violate the RICO Act. And I have heard many of the alleged overt acts and the conspiracy evidence to advance the enterprise through a pattern of racketeering activity and to control personal property and money. And I find that the factual basis for that exists. And I am going to accept Mr. Ryan's guilty plea. I find it to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences of this plea. And I'm going to sentence in accord with the recommendation that both of the state and the defense have worked hard to negotiate here, which is a sentence of 10 years commuted to time served and to be run concurrently with the sentence that Mr. Ryan is currently serving. And certainly within the court's consideration is the knowledge that Mr. Ryan is at this time serving a life sentence for the murder of Mr. Holmes. And while I understand that that is on appeal right now, you know, those are the facts as they exist right now. So that is the sentence of this court. Mr. Ryan, at 20 years old, you have most of your life ahead of you, and I don't know what it is going to hold with regard to your appeal or anything after that. But whether it is more years in custody or whether at some point in time you see the light of day to the outside world again, which is very likely considering your age, as long as you behave yourself while you're incarcerated and do not continue to either commit crimes in prison or violate any of the prison rules. If you can be on the straight and narrow, then somebody your age, after serving some amount of time, is probably going to be considered favorably for parole. And you just have to keep that in mind, that you need to be looking out for sort of the long run and not playing the short game, but playing the long game so that you have a future in front of you still. So that is your sentence, and I wish you luck, and I wish that with further maturity, much like Ms. Abbasi has said that you have already exhibited throughout the course of this trial, that you are able to make better decisions and steer your life in a better direction. Thank you.
And this is the other Quay who actually also negotiated a plea. So we had 4 individuals that was able to negotiate pleas. And again, we do see how the pleas work as a trial penalty. We can see what the guys were facing and what they're going to be able to plead to and perhaps one day come home. And so we're going to look at Quay here and see where we go from there. So here we go.
Please raise your right hand. Do you solemnly swear that the answer you shall give in the manner outlined before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hands down.
I think he already got sworn, so you're double sworn at this point.
Please state your true and correct legal name.
Marquavius Huey, MARQUAVIUS, HUEY.
And are you the same Marquavius Huey on indictment 22 SC 183572?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you?
28.
And how far did you go in school?
12th grade, high school diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you were in this indictment charged with count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act, which carried a sentence of 5 to 20 years?
Yes.
Count 3, you were initially charged with armed robbery, which carried a sentence of 10 to 20 years or life.
Yes.
You were charged with count 4 and 5 of this indictment, aggravated assault with a deadly weapon, which each carry a sentence of 1 to 20 years.
Yes.
You were charged with count 6 and count 7 in this indictment, which you charged of possession of a firearm during the commission of a felony.
Yes.
And that carried a sentence of 5 years to serve consecutive to any other count in the indictment.
Yes.
You were also charged with armed robbery in counts 14 and 15.
Yes.
Also charged with aggravated assault with a deadly weapon for count 16 or 17.
Yes.
You were charged with hijacking a motor vehicle in the 1st degree.
Yes.
You were initially charged with possession of a firearm during the commission of a felony.
Yes.
Counts 19 and 20. You were charged with 4 counts of participation in criminal street gang activity, which were counts 21, 22, 23, and 46.
Yes.
And you were charged with possession of a weapon by an incarcerated individual, which was count 44, and possession of a telecommunication device by an incarcerated individual, which was count 45. Do you understand that those were your initial charges in this indictment?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over this waiver of rights form with your attorneys?
Yes, ma'am.
And is this your signature on this document on page 4 of this document?
Yes.
Have you had enough time to speak with your attorneys, Carrington Matthews Sr. and Carrington Matthews Jr., about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this matter with your attorney?
Nope.
Are you satisfied with their counsel and representation?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes.
Do you waive any defects, if any, with respect to the indictment?
Yes.
Is it your understanding, have you been arrested on all of the charges contained within this indictment?
Yes.
And Mr. Matthews Jr., are you aware of any other outstanding warrants for these charges?
We are not aware of any.
Have your attorneys advised you of the minimum and maximum sentence for each charge that you are pleading to?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty which means that the state will recommend to the court the following sentence.
Yes.
Let me tell you the sentence.
Oh.
As to count 1, which is conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, the state's recommendation is 20 years to serve 9 years in custody, the balance of 11 years on probation. As to count 3, armed robbery, based on the negotiations, the state will reduce the armed robbery to robbery and offer a sentence of 20 years to serve 9 years in custody, concurrent with count 1, the balance of 11 years on probation. As to count 4, aggravated assault with a deadly weapon, the state will recommend 20 years to serve 9 years in custody, concurrent with counts 1 and count 3, balance of 11 years on probation. As to count 5, aggravated assault with a deadly weapon, the state agrees to null pros or dismiss that count. As to count 6, possession of a firearm during the commission of a felony, the state's recommendation is 5 years to serve, consecutive to counts 1, 3, 4, 14, 15, and 44 to be suspended. As to count 7, possession of a firearm during the commission of a felony, the state will null pros or dismiss that count. As to count 14, which is armed robbery, will reduce that to robbery, 20 years to serve 9 years in custody, concurrent with counts 1, 3, and 4, balance of 11 years on probation. Count 15, armed robbery, reduced to robbery, 20 years to serve 9 years in custody, concurrent with counts 1, 3, 4, and 14, balance of 11 years on probation. Count 16 will be null pros or dismissed. Count 17, that count will merge with count 15. Count 18 will be null pros or dismissed by the state. Count 19, possession of a firearm during the commission of a felony, will be 5 years to serve, 5 years to serve consecutive to counts 1, 3, 4, 14, 15, 17, and 44, but concurrent with count 6, and that will be suspended. Count 20 will be null pros or dismissed by the state. Count 21 will be 5 years to serve, concurrent with counts 1, 3, 4, 14, 15, 16, 17, 19, and 44. Count 22 will be null pros or dismissed by the state, as well as count 23 will be null pros or dismissed by the state. Count 44, possession of a weapon by an incarcerated individual, will be 5 years to serve, concurrent with counts 1, 3, 4, 14, 15, and 17. And counts 45 and 46 will be null pros or dismissed by the state. Do you understand that that's the state's recommendation?
Yes.
Do you understand that the total sentence is 25 years to serve 9 years in custody with a balance of 14 years? 9 of those 14 years will be served on probation and 5 years will be suspended. Do you understand that?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum of each charge and can run those charges consecutively, one after the other.
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions without being subject to revocation for the balance of the sentence?
Yes.
And do you understand that there were several special conditions of probation that you must adhere to, which are contained within this documentation?
Yes.
And have you had an opportunity to go over each of these special conditions with your attorneys?
Yes, ma'am.
And did you also go over with your attorneys your sentencing acknowledgments regarding this plea agreement?
Yes.
And is this also your signature on this documentation with your attorney going over each of the sentencing, each of the special conditions of probation?
Yes.
And did you fully understand the special conditions of probation?
Yes, ma'am.
Ms. Hilton, can you pass that document up to the court, please? Thank you.
Did you want to review before I continue? Did you want to review before I continue?
No, that's fine. Go ahead.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that you are not a United States citizen? A guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the courts, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
And let me make a correction to something I said earlier, because I just listened to her and she just read that out for Mr. Huey. And when she said the Department of Corrections and the Board of Pardons and Parole, the Department of Corrections is the prison system. The Board of Pardon and Paroles is the parole system for the state. And the federal parole system is, I believe it's called the Board of Parole. It's not what I said a moment ago. So when she said pardons and parole, she's talking about the state parole system. And when she said the Department of Criminal Justice, she's talking about the prison system. So I just wanted to correct that statement because I just heard it again. Okay. I think it's the Board of Prisons is what they call the federal.
Do you understand that you waive any and all defenses?
Whoops, and let me finish by stating because most federal prisons sentences don't have a parole. You have to do day for day, and then when you get close to the time for your time to be up, they send you to a halfway house. But normally it's about 6-month period stay for the most of the people that I've known that have gone to federal prison. And then you come out on probation. They give you a probated sentence after you come home to, I guess, see how well you're going to do once you get out of the halfway house. So their system is a little bit different than the state system in that regard. But they normally don't parole out of federal prison. It's day for day. Okay.
Including any mental health offenses by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And after each right, I'll ask you to respond. The right to trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
The right to assistive counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case.
Yes.
The right to presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charge against you proved beyond a reasonable doubt.
Yes.
And the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
With respect to indictment 22 SC 183572, how do you plead to the charges in that indictment?
I plead guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
And do you understand that you have until the end of this term of court to file a motion seeking to withdraw your guilty plea?
Yes.
Your Honor, if this case were to go to trial, the state would expect, or if we were to continue this trial, the state would expect to show, or evidence has shown and will show, that Mr. Huey conspired with others to participate in YSL through a pattern of racketeering activity, and multiple defendants, as well as unindicted co-conspirators, have committed overt acts to further this conspiracy, to include drug sales, aggravated assault, and murder. Also, it includes posting on social media, asserting the violent nature of and the dominance of young slime life, aka YSL. Specifically, Mr. Huey himself participated in 2 robberies. He posted on social media and he engaged in text messages with his fellow co-conspirators. On April 26, 2019, Mr. Huey, along with another individual, armed robber Mr. Dewan Maynard, at an apartment complex located on Masargo Drive in the Buckhead neighborhood in Atlanta, Georgia, Fulton County. He robbed Mr. Maynard at gunpoint and pistol whipped him. Mr. Huey was wearing a very distinctive yellow jacket. He stole a ring, a necklace, a luxury wallet, and other items. He then fled the scene in a black Mustang. Portions of this robbery, Your Honor, were caught on surveillance video. After the robbery, Mr. Huey was seen on his social media account with the ring and necklace that was identical to the items that were stolen from Mr. Maynard. Additionally, on Instagram and on social media, there were several pictures of Mr. Huey photographed next to a black Mustang. There were several pictures. Lastly, there were pictures of Mr. Huey on his social media wearing the same distinctive yellow jacket that was seen on the surveillance video. Based on that evidence, Your Honor, arrest warrants were issued for Mr. Huey. While on bond for the April 2019 armed robbery, Your Honor, on October 1st, 2020, Mr. Huey went to the apartments located at 250 Fulton Street, Atlanta, Georgia, Fulton County, to meet with Mr. Gary Holloman. Gary Holloman, who is now deceased, told law enforcement officers on the night that he was robbed that Mr. Huey, who he knew, asked to meet with him so that Mr. Holloman could give Mr. Huey money to put on another co-conspirator to Quarius Mender's books or commissary at the Fulton County Jail. Quarius Mender, who is a co-defendant and co-conspirator, is the nephew of Gary Holloman. Mr. Mender and Mr. Huey were friends or are friends. Mr. Holloman agreed to meet with Mr. Huey at the location. While at the location, Mr. Huey, along with another individual, approached Mr. Holloman. One person had an assault rifle. They took from Mr. Holloman his car and his money. They also robbed another young lady by the name of Demisha Coppage. Mr. Huey and the other unidentified individual fled the scene and left. Mr. Holloman immediately called the police. When police arrived, Mr. Holloman was able to use another cell phone to track his phone. He was able to track that phone going in the direction of I-75 South, and ultimately that phone was located on Oak Drive, which is in the Cleveland Avenue area, which is the area or territory for Young Slime Life. Also, Mr. Holloman was able to show police officers the social media pages of Mr. Huey to identify him. Initially, the police marked this case as an information, and the case was not initially investigated. However, about 1 month later, Mr. Holloman went to the police headquarters, spoke with investigators. He was able to pick Mr. Huey out of the photographic lineup. Subsequently, investigator Marissa Viverito, who was formerly with the Fulton County District Attorney's Office, found a jail call with Aquarius Mender, Mr. Mender's mother, as well as Gary Holloman discussing the robbery and Mr. Holloman discussing what occurred to him. Arrest warrants were taken out for Mr. Huey. He was initially arrested in November of 2020. During that arrest and pursuant to a search warrant, his home was searched. In that search, they found two rifle handguns. Also, they found items belonging to an individual by the name of Chandler Durham. During that search warrant, they seized Mr. Huey's phones and pursuant to a search warrant, did a search of those phones. Upon seeing the items from Chandler Durham, investigator Viverito checked the Atlanta Police Department database to find out there were any police reports associated with the Chandler Durham. She found a police report from March 12, 2020. In that report, Chandler Durham reported that while he was working at a music studio, his car and additional items to include a luxury bag were stolen. After finding the report, investigator Viverito went through the contents of Mr. Huey's phone, and she saw a few text messages of note. She saw a text conversation on March 12, 2020 between Jeffery Williams and Mr. Huey. Jeffery Williams told Mr. Huey that they needed to take that shit back. Mr. Huey denied involvement in taking the items and blamed it on another person. Mr. Williams then told Mr. Huey in his text message, if he doesn't take it back, he's going to die. Also found in Huey's cell phone were two incidents in which Mr. Huey and Mr. Williams were in conversation with each other regarding rival gang member Rashawn Bennett, aka Wife and Lucci. On January 19th, 2020, Mr. Williams sent a flyer to Huey with a performance location of Wife and Lucci. The text message read, handle that tonight, slat. Then Huey responded, slat. Your Honor, based on the state's understanding, slat means slime love all the time. Then on September 2nd, 2020, Mr. Huey sent a flyer to Mr. Williams with another performance location of Mr. Rashawn Bennett. Mr. Williams texted, slatty, handle, and stay very low. Huey's response was slat and for sure, I've been out the way. And appreciate you for everything, my brother. Never about money with me, I'm built on loyalty. Williams' response was slat, handle that, I got you. In 2021, we were able to recover another phone from Mr. Huey after he was subsequently arrested on grand jury warrants. When we did a search warrant of that phone, there was additional communication between Mr. Williams and Mr. Huey. Mr. Huey told Mr. Williams on November 14, 2021, you know I'm ready to handle the business and you'll sit down if I got to about any one of y'all on my mama. This text message followed information that was provided to investigator Viverito by Kenneth Copeland. Kenneth Copeland, during an October 2021 interview, advised investigator Viverito that he was aware of a potential plot to harm another rival gang member, Kelvin Watts, also known as Shell Kel, at a venue, Diamonds of the Land on Northside Drive. Mr. Copeland advised that he was aware that Huey was to participate in this plot to harm Watts, and he attempted to tell Huey not to participate. Lastly, Your Honor, on February 18, 2022, while housed at the Fulton County Jail, along with Aquarius Mender, they were both housed in the same cell. There was a search of that dorm specifically, and inside of the cell, there was a shank and an illegal cell phone inside of their cell that they shared. And based on what we know from other evidence that we have, that cell phone was used to communicate with other YSL members. Your Honor, this is the evidence that we believe would have come out had we continued with trial. Given where we are, Your Honor, and the charges, we made a decision to resolve this case with Mr. Huey for the offer that was relayed earlier, Your Honor. I mean, I have a copy.
All right, and with regard to the offer, I just wanted to be clear that on counts 6 and 19, which are possession of a firearm during the commission of a crime, while this 5-page plea agreement document reflects that those are going to be served on probation. The intention of both parties is that those 2 counts be suspended. Is that right?
Yes, Your Honor.
Okay,
Yes, Your
and in your global sentence, it says 5 years suspended, and so I assume that that's what y'all meant by that.
Yes, Your Honor.
Okay. All right. Mr. Matthews?
Yes, Your Honor. Good afternoon to this honorable court, Your Honor. I'd like to begin by expressing to the court that we emphatically and categorically deny all of the recitation that's been presented by the court with respect to some of these allegations that's been laid out by the state. However, we do recognize that there are enough factual allegations in the recitation to support each and every count to which Mr. Huey is pleading this afternoon. So we do stipulate that there is enough to move forward with this plea. For those reasons, Your Honor, we are standing before this court to talk to this court about the acceptance of responsibility with respect to Mr. Marquavius Huey. Your Honor, Mr. Marquavius Huey was born in Atlanta, Georgia. He lived in the Jonesboro South community, a neighborhood project in the Atlanta community. He grew up there. He's seen a lot of things in his short 28-year life. His father was murdered in 2010, and he's been without a father for a number of years. He's been raised by his mother as a single parent. He has a number of siblings. There have been times when Mr. Huey and his mother and his family have been homeless and have lived out of a car. So he's had a very, very hard life as it relates to his upbringing. Notwithstanding that, Your Honor, he did manage to graduate from high school. Mr. Huey, Your Honor, now has 2 children. He's 28 years old. He has 2 children. He has a 5-year-old son, Your Honor. He has a 2-year-old little daughter that was born in July of 2022. He has never met or seen his daughter in person until today, as she's here in this courtroom. He recognizes that choices puts him before this court in this case. Your Honor, we are asking this court to take into consideration that he has no prior felony convictions. I've had a very long time to get to know Mr. Huey because I've been with Mr. Huey on a regular, daily basis during the week since January of 2023. I've got a chance to know him. I've got a chance to work with him on his case regularly. And he wants to, when he gets out of custody, Your Honor, he wants to do a number of things, 2 in particular. He wants to start and become affiliated with a nonprofit organization where he can be able to talk to young children, teenagers, because he was a teenager when he lost his father, and things began to take a turn for Mr. Huey. He wants to be able to tell teenagers, young boys, young black boys, he wants to be able to say to them, don't do what I did, and you have another way in which you can go. And he wants to be able to share his experiences in that way. I have linked Mr. Huey up with an organization called Young Generation Movement, and I've known that nonprofit organization and the founder of that organization for a long period of time. He's also present in this courtroom, and I've linked Mr. Huey up with them so that when Mr. Huey gets out of custody, he will be able to have an organization that can mentor him, that he can align himself with, where he can begin to engage himself with anti-violence nonprofit conduct and mentoring other young people. He also, in terms of being able to earn an income, because he is now, Your Honor, if this court accepts this plea, Mr. Huey will now, for the first time, be a convicted felon. He is not first offender eligible. He wants to get his commercial driver's license, Your Honor, and he wants to get a trucking company and be able to earn a living for himself, because he recognizes that it's going to be a challenge for him to be able to go out and apply for jobs and be able to get income by getting an employer to hire him. So he's going to focus and target himself to be able to fend for himself so that he can take care of his young children that he has helped to bring into this world. Your Honor, we are here before this court because it's an acceptance of responsibility. We recognize that this has been a very long, enduring trial, and we have come to a point where we have painstakingly negotiated with the state of Georgia, and we've come up with a negotiated resolution that we believe is one that is fair. We believe that is sufficient to recognize the seriousness of the charges that are before the court. And we believe it's one that will cause Mr. Huey to be able to see the light of day in a reasonable period of time. Mr. Huey has been in custody. I'd like to enter into the record, Your Honor, as Defendant's Exhibit 1 for sentencing purposes, a proof of incarceration from the Fulton County Sheriff's Office. Mr. Huey, through the computations of the various times when he was arrested on these charges and released, and from the time that he's currently been in custody to the present, he has approximately 4 years under his belt against that 9-year sentence, and that 9-year sentence is parolable. So we're going to enter that as an exhibit before the court.
All right, that'll be Defendant's Exhibit 1 to this plea hearing. And as you know, and as I'm sure you have shared with Mr. Huey, it's ultimately the Department of Corrections that calculates the time served portion of the sentence, so it'll ultimately be up to them, but I will include that as a part of my sentencing sheet as well.
Thank you, Your Honor. Thank you. It's been an absolute pleasure and honor to represent Mr. Marquavius Huey, along with my son, Attorney Carlton Matthews Jr., who also would like to address the court at this time, Your Honor. So we're asking this court to accept the negotiation that has been represented to the court, and Mr. C.J. Matthews.
Yes, good afternoon to this honorable
Good
court.
afternoon, Mr. Matthews.
I've been gracious with this opportunity to represent and serve Mr. Huey. Mr. Huey is an honorable young man. Mr. Huey does not allow his mistakes to define him, but he is remorseful, Your Honor. He has learned, grown, and became a better man during this trial. Mr. Huey will have a release date, Your Honor. And I'm confident in him that he'll be a working class citizen in society when he is released. We thank this honorable court and we respectfully ask this court to accept this plea on today.
All right, thank you, Mr. Matthews. Mr. Huey, I am sure that Mr. Matthews Sr. and Mr. Matthews Jr. have, I know that they have been working with you and negotiating with the state for over, I'm sure the entire course of this trial and proceeding, but very, very hard over the last week and a couple of days to get where we are right now. And I know that you know that given the severity and the number of charges that you were facing, that had you been convicted of all of those charges at trial, you were looking at the possibility of 3 consecutive life sentences, plus I think about 100 years after that. So the fact that the state is recommending jointly with your attorneys that your total sentence be 25 years with 9 of those to serve is, it's frankly remarkable. And something that you should not take for granted or take lightly at all. These are very serious charges. And I hear what both Mr. Matthews have said about the challenges facing you in your life, and I am sorry for the loss of your father. One would hope that to have anybody that they love taken from them in a violent way like murder might have an impact upon their lives that would lead them in the right direction, but it's not particularly surprising that sometimes that's not what happens and it goes in a worse direction instead. I hope that with your age and with having really been faced with the distinct possibility of spending the entirety of the rest of your life in prison, the fact that you are getting this opportunity is not going to be wasted. I hope that you appreciate what the Matthews have done to go out of their way to line up somebody to be looking out for you when you are released from prison. And I want to ask you, just like I have asked both Mr. Nichols and Mr. Ryan, is this your decision to enter this guilty plea? Because no matter what your attorney's advice is, it's ultimately up to you whether to plead guilty or continue with the trial. So is this what you want to do?
Yes, ma'am.
All right. And have you had enough time to consider all of the different scenarios and to discuss everything you wanted to with your attorneys?
Yes, ma'am.
All right. All right. I think it's very clear that this plea is to your benefit, considering the potential downside of moving forward with the continued trial. I find there to be a factual basis to this plea. I appreciate the fact that y'all have stipulated that there is a factual basis. And I find the plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I will accept it as such. And I will sentence in accord with the negotiated recommendation. I'm not going to read everything out again. We've thankfully got it in writing for the sentence sheet, but in accord with what was put on the record and what is reflected in this, this document. With a total sentence of 25 years to serve 9 in custody, balance of 14 years after that, 9 of those on probation and 5 suspended. And I'm going to impose the special conditions that you have already acknowledged and acknowledged that you would abide by. And, you know, somebody with a high school diploma, which is more than a whole lot of people ever achieve. So you've already achieved and proven that you can achieve good things, and who is only 28 years old, and who can really look down and already see the light of day for a release date. You need to make sure that during your time incarcerated that you don't pull any of the kind of thing that you have been, you know, that you actually are pleading guilty to at least some of by having contraband or in any other way getting in trouble, because that's not going to bode well. I am going to recommend a transition program for you. I know that there's a lot of different job training available in our correction system, so I hope that you take advantage of that. And you know, whether it's a commercial driver's license or whether you find something else that you want to do while you're in there, be making good use of your time while you're in there, and furthering yourself, and you have had a fine example next to you for the past 2 years of what somebody can do with their lives. So don't forget about that, and be the father that you need to be and that you ought to be to your very young children. They're still going to be very young when you get out. And please make sure that you abide by all your probationary conditions, because if you don't, then you're going to be back to see me. And because I recognize how much of a break you're getting right now, I'm probably not going to be as lenient if you come back before me again, because you are getting a huge opportunity to turn your life around. Okay.
Yes, ma'am.
All right, so that's the sentence of the court, and I want to wish you good luck and good fortune. You can get through the next few years, and then you can have the rest of your life to do good work with.
Can you address the court?
Yes. I should have asked that. I'm sorry.
That's okay, Judge. Thank you.
I want to thank the court and thank God. And I want to apologize to my kids, my family, and everybody who done supported me in this stressful process. And, I plan to do my time, come back, be a better man.
I'm glad to hear that. Thank you.
Your Honor. Thank you.
All right. All right, let's take a recess.
So there you have it, all of the plea deals that let you know just how the trial penalty works. It would have been absolutely beautiful if those young men could have gone on through the trial and been found not guilty of the RICO. Certainly not whatever the things that they are actually guilty of. But, you know, it's the luck of the draw. And it's something that mothers ought to really think about with their sons and daughters, because peer pressure is really strong. And especially in communities where, you know, everybody really is on the same page, because pretty much everybody is disenfranchised and at the lowest level of the ladder. But there is hope. And there are steps, and they can be climbed. But we got to start teaching truth and teaching people how to be who they are, which are Americans, and how to live according to the many documents that are out there. It's just a matter of getting a hold to them and reading them. I wanted to play Jeffery's whole interview, but I think I'm not going to do that because I have a lot more reading and writing to do myself. But I wanted to come on because I felt well enough to come on and, you know, give my new people and my old an opportunity to hear my point of view on these things that are going on right now. And again, no matter who you cast your vote for, get active. Learn the Constitution and learn how to enforce it. And know that a lot of things surround us is involving the criminal injustice system. The fee system, you know, we have to pay a fee for everything. The FICO scores and how they affect us in all areas of life, even right down to buying auto insurance. Used to be a time when you turned a certain age, your insurance, you know, would drop in cost. Not so much today. Today, if your FICO score is a certain number, and that's your credit score that they use to decide if they want to grant you credit. If your credit score is a certain number, then your insurance premiums are much higher. though everything seems to be against you, but it's all about you and the decisions that you make. And so I'm going to get ready to close and wish everybody a good night. We've been here 2.5 hours, and so I thank you for being here with me. And we're going to say good night to my favorite little old song, The Children Are Our Future. And let's try to teach them well and help them find the way. We've got to do that. Got to get honest with ourselves and with our babies. Life will be so much better. So much better. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. A lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, at least I'll live as I believe. No matter what they take from me, they can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.